Dear colleagues, ladies and gentlemen, thank you very much for the invitation. I'm happy to have the possibility to share some reflections on international legal dimension of surrogacy trade. In my opinion, we are living in interesting times. There is a saying of, I think, Chinese origin, because most of legal systems in the world say that maternity is related to woman who gave birth to the child. And it is complemented by paternity of man, father, often married. However, in some states, this kind of competitive a contractual way of acquiring legal status of mother or father or homosexual parent A or B has been introduced. And we can also see postulates, even demands to change family law, also in the states generally not allowing, in this sense, prohibiting surrogacy. Those demands are or direct, so directly by changes to substantive personal or family law, for example, civil or family code, or indirectly, sometimes it's said at least, by recognizing the effects of foreign law, for example, birth record or foreign court procedures, a kind of procreative tourism and surrogacy trade. Is public opinion aware of the real content of current legal concepts called surrogate motherhood? I would answer no, definitely not. Two examples. With the word surrogate mother is described not the woman or man with this final status of parent, but a woman who had been pregnant and contractually transferred the parental status to another person. The last person, in fact, is surrogate in relation to pregnancy and birth. Second misunderstanding is the controversial issue whether delivering the child to single persons or same-sex couples can be logically described as surrogate. As we know, these forms of surrogacy does not substitute the general result possible in biology, but creates a specific, let's say, abiological legal fictions. So summarizing, under the slogan of welfare and kind of guise of good, also a business, a trade, contrary to human dignity is developing and is connected, of course, with the objectification of women and also situations comparable to the trafficking of children. In my opinion, these are also examples of violating the ideas of international law. For example, the Hague Convention, 1993 Hague Convention, prepared under auspices of Hague Conference of Private International Law. This convention declares clearly that no payment or compensation of any kind, Article 4, and then says about non-profit objectives, Article 11 of inter-country adoption. I would also stress an important role in future actions of private international law instruments, especially in those countries where local substantive private law do not provide for surrogate motherhood. Private international law and international civil procedure is crucial to consistency of the system and the effectiveness of ban. Every country, such country, means not to recognize, we would say, not to import filiation effect of contracts concluded abroad. So not to recognize the protection not to recognize this kind of procuration tourism. Otherwise, the protection of local old public will be only theoretical. The national ban otherwise will be only theoretical. Another important legal issue is access or contact with children and the responsibility between the given child and persons in close actual relationships. But this is the matter, this is another thing, this is the matter of the scope of 1996 Hague Convention. In my opinion, in the future international convention, may be discussable the allowing the exception of altruistic contracts. I know that it can be problem, and it is problem, but maybe for the purpose of the success and aiming to the success on international agreement, it could be thought, because the success of the convention, of the proposed convention, will be counted by the number of accessing state. Maybe, I'm not sure, this is my first thought, maybe a reservation, it is a mean known in public international law, could solve these problems of countries, of states who would like to reserve the surrogacy only for internal domestic purposes and only without any benefits, without any payments. And if those conditions would be controlled. This is another issue. Coming back to the main thoughts, summarizing, many general fundamental questions arise on the international dimension of surrogacy and this trait. And for example, these questions are, do public opinion really know what is the content of legal solutions called surrogate motherhood? I'm not sure. I'm not sure if public opinion know how is the reality, what is it in reality. The second question is whether the current state of play could be critically evaluated as, firstly, a kind of back to the future, despite the abolition of slavery, back to the past, despite this abolition of slavery, plus assisted reproductive technologies. And secondly, it is combined with a kind of asexual, I would say, innovations, which means delivering children to single persons and same-sex couples. The second question is the activities of international tribunals. Will accepting by the tribunals some effects as exceptions in individual case will lead to the law-making effects and future change of law. The next question is whether it is coherent and consistent. In my opinion, no. To evaluate surrogate motherhood negatively in a country for domestic purposes, and at the same time accept the effect of similar contracts abroad. And the last question is more general. Are the declared human rights protected? Are they in action? Or nowadays, the protection of women and children is in fact defunct? And by the way, I'd like to present a book prepared by a group, a team, international. It was an honor and pleasure to work with this team, called Fundamental Legal Problems of Surrogate Motherhood. And this book is accessible, for example, at books in Google. It is written by over 30 international experts, and the idea was to give readers food for thought. And the approach is similar to the conference and the ground for the declaration. The phenomenon called surrogate motherhood should be negatively evaluated, both from the perspective and achievement of various branches of law, as well as the general approach of human sciences to the issue of human dignity. Thank you for attention.